Hi viewers, welcome to the second episode of What's Brewing. What's Brewing because we love our favorite cup of brew, and we also want to reach out to what's happening on the ground. We have with us today Amarjit. Amarjit, welcome.
Thank you, Mel.
So Amarjit's a dear friend, and she is a partner at Withers KhattarWong, where she's involved in litigation and arbitration. And she has been a qualified lawyer since 2003. Amarjit, am I right?
Yes, that's
Without
right.
giving your age away, of course. And in her career, she's represented Fortune 500 companies on corporate and employment issues, and she's been noted for her expertise in labor and employment law. And the 2019 edition of the Legal 500 Asia Pacific, she was cited, and also in 2017, she was recognized by the Singapore Business Review as one of Singapore's most influential lawyers aged 40 and under. So I also know Amarjit's a very humble person, so if I go beyond this, she's going to kill me. So I'll stop there with her introduction because there's a long list of achievements. Amarjit, welcome. And we are going to discuss something that hits home hard today. In this COVID-19 situation, employment and jobs are critical and certainly very vulnerable for a lot of people. And Amarjit, you being in the industry, advising a lot of clients on employment and labor issues, we thought it would be great to talk to you today on this and get your insights into what's happening on the ground with regards to how employers are looking at this. So, based on the queries your firms have been getting, Amarjit, what state would you say the job market is in right now, and are mass layoffs on the horizon?
Mel, I have to say that it's a somber topic to be touching on because we've had a lot of inquiries from employers recently, both existing clients and new clients, who are faced with a novel challenge of, firstly, the uncertainty of knowing whether their business will survive the coronavirus pandemic, and secondly, with the question of what do we do with our manpower who is now either sitting idle or who are doing a much reduced scope of work. So do we continue paying them? Do we retrench them? What are the options? We've had a lot of queries of this nature. I think by and large, most employers are trying to keep on as many employees as they can, but it's a practical problem that they have to address because their overheads are continuing to run while their work pipelines have almost dried up
Sure.
in certain industries at least. So this is something that's very real. I do foresee fairly large scale layoffs on the horizon. I think there is a certain inevitability to this. Now, how quickly we will bounce back from this and recover with employment rates going up is the question. Unemployment will rise, job vacancies will drop because people are having hiring freezes at the moment. So I think new jobs are unlikely to be advertised soon. So these are the sort of changes I foresee on the horizon for the employment market here in Singapore.
Yeah, it sounds bleak. In terms of where the trouble may be brewing more, what sectors or types of jobs are we talking about where you see more of this happening?
Mel, I think almost every industry is impacted. Almost every client from different industry sectors are all facing serious troubles and issues. I would say primarily hospitality and tourism, F&B, construction. These are the ones that are most heavily impacted, and this is sort of recognized in the budget as well. But it's not just limited to these industries. Clients in the tech industries, marketing industries, etc., are letting go of people as well, or considering other options to manage their excess manpower.
Right. And the government has, you mentioned the budgets, the government has provided some support for jobs by paying 75% of local employees' salaries. This is the job support scheme, of course, we're talking about. Why is there still a need for employers to consider laying off workers then when there's so much support in terms of wages?
Okay, so Mel, the 75% actually kicks in for the month of April, and this is an enhanced amount to account for the circuit breaker. And during this period, non-essential services, as you know, have either had to shut down operations, or if they can work remotely, then they are operating remotely. But the reality is it is for 1 month only, and it only goes up to the 75% of the first 4,600 per employee's salary.
Right.
So for the employers that hire workers or employees with higher salary bands, this doesn't really account too much. And the reality is, beyond April, for the other months that are covered, it's a staged support. So for it's industry specific. So for the tourism and the hospitality aviation industry, it's 75%, F&B is 50%, and other industries is 25%.
Right.
And even within the industries, Mel, it doesn't apply to every company operating in the industry. And I'll give you an example. I have a that's a hotel operator. They are a homegrown company. They run about 11 hotels in the region. Now, because they are not licensed hotel owners, beyond April, they will not qualify for the 75%. Instead, they will be within the 25% bracket.
So what do you mean when
So,
you say they're not licensed, as in they are like Airbnb sort of providers, or?
as in the operators, so they run the hotels for the hotel owners.
Right, okay.
They sort of offer the management service, so they manage all the workforce for the hotel owners,
Sure,
etc.
sure.
But because of because of how their ACRA filing was set up, they don't have the relevant code to benefit from the 75%.
I see.
So it's a very real issue they are facing because they hire a significant number of Singaporean employees, being a homegrown company, but they can't avail themselves of the full benefit. So they've actually put in an appeal. I mean, the government's flexible in that they consider appeals. I think that's wonderful. But I do think that it's a real issue that they still have to bear the burden of a large part of employees' salaries, even with that provided.
So you think that's why there is a need then for employers to look at headcount and look at it as a immediate cost-cutting measure?
Absolutely. I think it's one of the largest cost items for a lot of employers.
Sure.
And it's one that's continuing to rack up, even though their business is drying up.
Yeah. But on the other hand, it's also not as straightforward for employees to lay off workers, is it? I mean, there's a lot of regulatory hurdles for employers to cross before they can actually outright retrench someone. Could you take us through some of these considerations, perhaps?
Sure. So, Mel, as you know, Singapore traditionally is a very employer-friendly jurisdiction. We attract companies and MNCs to set up business here by offering them a landscape that protects their rights. Now, in recent years, we've seen a shift towards employee protection. So, whilst it is not extremely simple to let employees go, to retrench them, it isn't as difficult as you would expect. So, for example, if a company is a small SME that employs less than 10 employees, they can actually let the employees go with impunity. So that means that they can retrench them. They don't have to report to the MOM, which is not the case for employers who employ more than 10. They have mandatory reporting obligations.
Sure.
If they're smaller companies, they can actually just let the employees go. Now, the question is how they would do that, right? So in many cases, we see employers letting employees go on the basis of contractual termination.
Yes.
So let's say a contract says, 3 months notice. The company will say, we're giving you notice, and we either pay you salary in lieu of notice, or we expect you to serve your notice. Now, what we are seeing, a lot of employers are saying, don't serve your notice because we don't have any work for you. Another phenomenon that is interesting is a veiled retrenchment.
Yep.
Or bias retrenchment, which is where they don't call it what it is, they call it anything but. So we have seen cases where it's labeled misconduct or poor performance. Now it's interesting because last year in April there was a guideline introduced on wrongful dismissal, which put the burden of proving this misconduct or poor performance on the company.
Right.
So since then we have seen a lot of companies moving towards contractual termination without any explanation.
Right.
So they just say the contract, we're entitled to terminate you, we don't give you a reason. But what that means is that the employees are deprived of retrenchment benefits. And that's a real problem.
Absolutely. And also, I mean, now that since the employment market is such that a lot of people are hired on a contract basis, a lot of companies can also phase out the contracts and just, avoid that as a loophole as well, right?
Yes, contract workers probably going to be the first to go.
Yeah.
Alongside those employees who are very expensive, so the C-suite guys, the high-ranking execs, because they draw the highest salaries. Same with people whose skills are replaceable, either by automation or by rehiring when the market picks up. So these are the more vulnerable groups at the moment.
Right. And there's also a requirement, if I'm not wrong, where the company, as long as the company retrenches not more than 50% of its staff in 6 months, it doesn't have to report to the agencies on this. Is that right?
So, if a company employs 10 or more people,
Right.
as long as it has retrenched 5 people,
Mm-hmm.
it has notified the MOM.
Okay.
So, whether that 5 constitutes 50% or 10%, as long as they hit the threshold of 5,
Right.
the reporting obligation kicks in, and it's mandatory that they report. And then on the back end of this, the MOM exercises scrutiny into the type of retrenchment practices. So they look into factors like whether there has been discrimination, in terms of whether, for example, age discrimination or discrimination against a pregnant employee. I have a recent case of an employee who was a C-suite in a tech company who was let go after she told them she was pregnant, which was 2 weeks ago.
Right.
So you can see this sort of discriminatory practices kicking in, and it's good that the MOM exercises scrutiny into these sorts of things to ensure that there's a level playing field, and even when people are being let go, it's
Absolutely.
not in a discriminatory manner.
Absolutely. So let's talk about from the employee point of view, because a lot of our viewers will be interested in this as well. So if one is retrenched, what sort of compensation can they rightfully look for? And if one feels that one is wrongfully dismissed, then what is their course of action?
Okay, so we have a creature in Singapore known as the Employment Claims Tribunal,
Right.
which was set up as a low-cost, effective means of resolving these types of disputes. It falls within the state court mechanism, so it is a court in itself, but no lawyers are allowed, which means that the filing fees, etc., are actually quite low.
Right.
Now, the downside of going to the Employment Claims Tribunal is that the claims are capped. So if you go through the mediation process that comes before the ECT, you're entitled to claim 30%, 30,000. And if you skip the mediation process, your claim is capped at 20,000, which means that if sum you're claiming is actually above that, you have to give up that part of your claim.
Right.
So for some employees, this is not really an ideal solution because they're looking for far more in terms of compensation, in which case they have to go through the usual civil justice route and file a civil suit to claim. Now, the ECT, if they're wrongfully dismissed, now again, wrongfully dismissed can fall under various categories, right? If you are dismissed to deprive you of a benefit, for example, retrenchment benefit, that's a wrongful dismissal. If you
Yes.
are dismissed, you are told you are dismissed for a certain reason, but you were actually being let go for another reason, that's also wrongful dismissal. And another interesting feature is constructive dismissal, which means that the employer doesn't dismiss you outright, but puts you in such a situation that you have no choice but to tender your resignation. So that's another form. So these are the sorts of creatures that are covered under wrongful dismissal.
Right. Right. And in terms of compensation for in terms of retrenchment, you were saying that there's a certain criteria as well, right?
Yes, so generally the broad guidelines for retrenchment are 2 weeks to a month
Right.
per every year of service.
Okay.
Now, under the Employment Act, employees are entitled to this if they've worked for the employer for 2 years.
Okay.
If they haven't, it's ex gratia, so it's a goodwill payment. Now, the tripartite guidelines, which provide this band of 2 weeks to 1 month, isn't actually law. The Employment Act doesn't prescribe how much should be paid. So it's usually what's in the contract. If there's nothing in the contract, then guidelines prescribe 2 weeks to a month. Now, even within that, there's scope for wiggle room for companies because it is industry specific. So it accounts for industries, and it also accounts for financial situation of the company.
Sure.
Which means if the company is not in a good financial situation, it can say, I can't afford to pay you this. And that's what we see happening.
And there's no recourse for that for the employee.
So the recourse is to try and go to the ECT and try and get something,
Right.
or to try and negotiate. Because honestly, sometimes if the company isn't in a position to pay, then the best thing you can do is to work it out with them.
Right.
Alternatively, if it used to lie with the MOM, now it's been moved to the ECT. So the ECT is probably the first cause of recourse, if the person wants to work within the cap. Otherwise, it's a civil suit.
Okay.
And then what the ECT normally orders is either reinstatement to the job. So if they feel the person's been wrongfully dismissed, they can order the company to rehire the employee. So where things haven't gotten bad, the relationship hasn't deteriorated, they can order that. Or they can order that the salary be paid from the time of wrongful dismissal or compensation.
Okay. Well, it is a very bleak proposition, Amarjit, and I hope that none of our viewers have to actually go through this course of action or face these consequences. But
Yes.
then again, looking at how bad things are and becoming, you never can tell. And
Yes.
I do also think that perhaps we might be seeing another package come in to help out with the jobs, since jobs has been the preoccupation of this government for as far as we can remember. Thank you for your time,
I
Amarjit. We are grateful for you spending your time with us, and
Thank you.
yeah, thank you so much. Look forward to seeing you again. Take care.
Take care.
Bye bye.
Bye. Bye.